Hello everyone and welcome back to the channel and welcome to the final chapter of our little mini-series on the criminal litigation process. We've gone all the way through the episodes from arrest and charge all the way up to sentencing and appeals, and now the final chapter, standalone chapter, just looking at the youth system in comparison to the adults. If you haven't watched those episodes, do highly recommend you go and watch those, both for those who are studying the law for their exams and even the general public if they just wanted a bit of an insight into the criminal process. Just a reminder, this is based on Blackstones syllabus 2025, so if you are undertaking exams, please refer to your latest syllabus for any changes. Do thank everyone for liking and subscribing. It does help create further content for the channel, and we hope to see you on those other videos. So in this chapter, we're looking at youth courts, and it's a distinct part of the criminal justice system designed not just to punish, but to prevent offending and rehabilitate young people. Youth courts deal with defendants aged 10 to 17, and their guiding principle under Section 37 of the Crime and Disorder Act 1988 is simple: to prevent offending by children and young persons. And if you remember, on one of the early episodes, we did mention that we do need to address any criminality at a young age just to prevent this domino effect and it becoming routine behaviour going into adulthood. So let's explore how that philosophy shapes everything from procedure to sentencing. So who is a youth? A youth means anyone aged 10 to 17 at the date of charge in terms of criminal law. Below 10, a child cannot be held criminally responsible. And it's important to remember, once charged, the person stays within the youth court's jurisdiction, even if they turn 18 later in the process, unless the court directs otherwise. The court is a special type of magistrates' court, and it deals with nearly all offences committed by youths, both summary and either way offences. However, the most serious crimes, known as grave crimes, and we'll look at that later on in the video, or cases involving adults charged jointly, can be sent to the Crown Court. And we'll return to that shortly when we discuss transfers and grave offences, but it's very much a balancing act. It can be quite intimidating to go to the Crown Court for a youth, so it's very important to balance that against the seriousness of the offence. So under Section 37 of the Crime and Disorder Act 1998, the principal aim of the youth justice system is to prevent offending by children and young persons. The system places a strong emphasis on welfare and rehabilitation, guided by the Children Act 1989. You might remember when we covered the adult system, it's very much an adversarial system, whereas this is purely based on welfare and rehabilitation in contrast. Youth offending teams, or YOTs, play a major role, offering tailored support plans and intervention programs. The goal: to stop young people from becoming repeat offenders and to reintegrate them back into society. So how does a youth court look, you might ask? So youth courts look and feel different from adult courts. It's very much less formal, no raised dock, fewer robes, and a smaller courtroom setting. Most importantly, hearings are in private, meaning the public cannot attend. And this privacy protects young defendants' identities and supports their rehabilitation. Under Section 49 of the Children and Young Persons Act 1933, reporting restrictions apply automatically to anyone under 18. So you may have seen some quite high-profile cases in the news where the name and identity of the defendant is not disclosed if they're a minor. And what about the composition of the court? So a youth court usually consists of either a district judge in the magistrates' court or a bench of 2 or 3 specially trained magistrates, and they normally trained within the youth court system. They sit again with a legal advisor, and unlike the Crown Court, there's no jury. So this structure helps create a more supportive and less intimidating environment for young people. So representation, again, is important. Every young person has the right to legal representation, and the court must ensure they can understand and participate effectively. This often means adapting the language used, involving a youth offending team officer, and in some cases using an intermediary to help the youth follow proceedings. Participation and understanding are critical. It's not just about being present, but about being engaged, so they need to understand what's happening. Parents or guardians are normally required to attend the hearing, and their presence ensures that the youth has emotional support and understands the process. The youth offending team is also there to guide both the defendant and their family, offering reports and supervision recommendations to the court. Youth courts can try summary and either way offences, but they must consider if a case should be sent to the Crown Court. And this is normally based on two main reasons. Either one, there's a case involving a grave crime, and this is a serious offence, normally over 14 years of imprisonment for that type of offence, such as robbery, rape, wounding with an intent. Or two, the youth court is being tried jointly with an adult, and it's in the interests of justice to require the case to stay together. So if you can imagine running two separate cases where the details of the offence and the circumstances, evidence is all interlinked. It's not the most efficient process, but as I said earlier, it's got to weigh up the intimidatory factors for the youth by going to the Crown Court. And grave crimes, just a little summary here, defined under Section 91 of the Powers of Criminal Courts Sentencing Act 2000. Normally offences carrying at least 14 years imprisonment for adults, including manslaughter, robbery, aggravated burglary. When a youth is charged with such an offence, the youth court must assess whether its sentencing powers are sufficient. If not, the case will be sent to the Crown Court for trial or sentencing. Bail remains a starting point, just as with adults. If you remember back to chapter 4, I believe it was, bail. But there are special safeguards for youth. So if bail is refused, the court may remand the youth to local authority accommodation, or in serious cases to a secure accommodation. And this is governed under the LASPO 2012 Schedule 12. Youth remand decisions always balance public protection and the youth's welfare and development needs. Youth courts can impose a wide range of sentences tailored to rehabilitation, and these do range all the way up from absolute discharges and referral orders to detention and training orders, DTOs, of up to 24 months. So I do recommend you go to your syllabus and do some further reading on that. It is fairly detailed. Take some time to get your head around. The key difference, though, every sentence aims to correct behaviour, not simply punish it, like the adversarial system in the adult courts. So referral orders are the most common sentence for first-time offenders. The youth must meet regularly with the youth offending panel to agree a contract, focus on reparation, education, personal responsibility. Reparation orders, meanwhile, require the youth to give back to the community, perhaps repairing damage, like this young chap here who's graffitied the wall, or performing supervised work. And these orders embody restorative justice in practice. And custody is always the last resort for young offenders. Only the most serious or persistent offenders receive custodial sentences, and detentions may be served, for instance, for ages 15 to 17 in a young offender institution, a secure training centre, or even a local authority secure unit. But even in custody, the youth's education and welfare remain central priorities, just to prevent any further criminality embedding itself into adulthood. So we touched upon this earlier. So under Section 49 of the Children and Young Persons Act 1933, all youth proceedings are automatically subject to reporting restrictions. This means the press and public cannot publish the name, address, school, or photograph of a youth involved in proceedings. The court can lift these restrictions, but only in exceptional cases, usually to serve the public interest. So that's a lot of detail. This is a fairly detailed element of the course. But just to summarize the main distinctions between youth and adult criminal justice, hearings are in private, not open to the public in the youth system, and the terms differ. So youths receive findings and orders, not convictions or sentences. Also remember, age of criminal responsibility is 10, so anyone under 10 is deemed not to be criminally responsible, and they can't be tried. The system prioritizes rehabilitation over punishment, and the maximum custody 24-month detention and training order. Detention takes place in specialist youth facilities, not adult prisons, and parents and youth offending teams play an active role and an ongoing role. These differences reflect society's belief that young people deserve a chance to reform and not just be punished at the first instance. So just to recap, Chapter 10 that completes chapters. Youth courts are built on 3 foundations: prevention, welfare, and rehabilitation. They balance accountability with compassion, recognizing that young offenders are still developing and can be redirected. If you found this breakdown helpful, hit the like button, subscribe to the channel, drop a comment. If you have any questions, I will try to answer as many as I can. This does complete the 10 chapters of the criminal litigation syllabus. It's just a very condensed version overview, just a taster for you to go away and do some further reading. As I said in one of the earlier episodes, we will make some further dedicated videos such as hearsay, just to look at some of the areas of law in a bit more detail, because we did kind of gloss over some of the main areas here. So I do put that disclaimer, and you do need to do some further reading. And I have actually filmed a video recently, I'll release this soon, of Birmingham Crown Court and Magistrates Court, just as a walk around tour. So look out for that video. But thanks for watching, everyone. Hopefully you did find that informative. Good luck with your legal studies if you are studying. If you are going through a legal issue, good luck with that. Please consult legal representation. Hope to see you on the next video. Bye for now. Take care.